go ahead and get started. So thank you all so much for being here. It's wonderful to have this group gathered to hear from Dr. Brunilda Pali. I get the honor of introducing her today. So my name is Lindsay Pointer. I'm the Associate Director of the National Center on Restorative Justice and an Assistant Professor at Vermont Law School. And we made, the decision. We have the wonderful fortune of having Dr. Brunilda Pali with us here in Vermont as a visiting scholar this week, which is just wonderful. We made the decision to still have this main seminar over Zoom due to kind of ongoing COVID concerns. And the wonderful part about that is I saw in the registrations people joining us from even outside of Vermont. So that's really a wonderful thing about these virtual spaces, is that it allows us to kind of have a wider reach and more people can hear the wonderful message that she has to share. For those of you who are in Vermont, there will be opportunities throughout the remainder of this week to meet with her in person in smaller circles as well. But this is a great opportunity for us all to be introduced to her work in this wonderful field. So by way of introduction, I want to share a little bit about Dr. Pali's background and current role. So I have a bio to share with you here. So Brunilda Pali, she's a senior researcher at KU Leuven in Belgium and a lecturer at the University of Amsterdam in the Netherlands. She's currently a board member and secretary of the European Forum for Restorative Justice. She's co-edited the Critical Restorative Justice and Restoring Justice and Security in Intercultural Europe. And she's currently co-editing the Handbook of Environmental Restorative Justice. So on our theme of today, research methods in restorative justice and widening the restorative lens. So lots of great work in bringing people together. Brunilda has studied psychology at the University of Bosphorus in Istanbul, gender studies at the Central European University in Budapest, cultural studies at Bilgi University in Istanbul, and criminology at KU Leuven in Belgium. And her areas of interest include gender, critical social theory, environmental and social justice, restorative justice, cultural and critical criminology, and the arts. And I'll just say on a more personal note that I have found Dr. Pali to be one of the most inspiring leaders in the restorative justice field today. Her work is always on the cutting edge, on the frontier of creative applications of restorative justice. So it's an absolute honor to have her with us this week and to have this opportunity to hear from her today. I have no doubt that you all will find her work quite inspiring. So if you are ready, Brunilda, with that, I will go ahead and turn it over to you. We'll have time to hear from her, and then we'll have time also for a Q&A session at the end, which I will help to facilitate. So as we go, if you have questions and you want to drop them in the chat, that's great, or else you can save them and unmute yourself to ask them in person at the end of her talk. So thank you so much, Brunilda, for being here. We're excited to learn from you.
Thank you very much, Lindsay, for that very kind introduction. So good morning, good afternoon, good evening to everyone, depending on where you are. Before starting my talk, I would like to thank very much the National Center on Restorative Justice at the Vermont Law School for inviting me to give this lecture on responses to environmental crimes, conflicts and harms, and especially Lindsay Pointer, Professor Lindsay Pointer, whose sustained engagement with the application of restorative justice in very different fields is also highly inspirational for many of us in the field. So I have a little PowerPoint to share, and we'll, try to see how that works with all the technical issues possible. There you go. So can everybody see the PowerPoint, and can you also see a little bit of me in the background? Yeah, okay. So yeah, I mean, I'd like to start this lecture by saying that essentially in the last decades, we've had many advances when it comes to drafting and adopting declarations, agreements, treaties, laws, and there's certainly been extensive progress, when we are thinking about improving the technical side of environmental protection and regulation. We have also, this is questionable, but in my opinion, we have reached a stage of relatively wide cultural and social environmental consciousness, and this can be testified by the broadly endorsed climate and youth activism, a global movement for the ecocide law and the rights of nature, and many citizen-led environmental and climate change litigations. Yet, I think that despite, on the one hand, this incremental sort of improvements on the regulatory and the protection side, and this other kind of, if we can call it, ecological conversion in a certain way that has taken place at the collective consciousness level, we are yet to develop any sort of meaningful accountability, justice and repair in cases of environmental harms, crimes, and conflicts. Responses to such type of cases are inevitably situated at the intersection of a multitude of ideas and aspirations that can revolve around law, rights, justice, restoration, activism, regulation, and so on. And so in this lecture, I think I'll try to argue that restorative justice is very well placed at sort of, and uniquely placed at closing the gap between these sort of different approaches and different worldviews and perspectives. Restorative justice today is a global social movement and an alternative justice paradigm that aims at fundamentally transforming the way our societies react to crime and conflict. And it prioritizes the harm that has been caused over the laws that have been broken. That's the starting point. It also involves all stakeholders in the justice process instead of delegating the matter. And finally, it searches for ways to promote repair and accountability instead of promoting punishment for punishment's sake. And even though we can argue that restorative justice today is still a very anthropocentric approach, of course, thanks to its sort of underlying relational philosophy, I think it has the potential more than any other justice approach to incorporate ecocentric perspectives, indigenous justice approaches, and perspectives from the right of nature movement. Okay, so here we go. It's not easy to move this. Okay, just works there, fine. So in this lecture, I will therefore largely sort of focus on the, let me just do this so I can only see, yeah. Sorry for a second, it's just figuring out what is the best. Yeah, that's it. So I'll largely focus on the potential of restorative justice to environmental harms, crimes, and conflicts. Nevertheless, as I'll argue, this engagement presents also a set of very specific conceptual and practical challenges that are not present, or let's say manifest differently, in other areas where restorative justice is applied. So we will also try to think a little bit and touch on those. And finally, I think something that I will also focus in the lecture is by presenting some existing experiences. So first of all, what gifts does restorative justice bring? First of all, as implied in my title, differently from more sort of narrow or specific approaches, environmental restorative justice can potentially respond to all the spectrum of environmental crimes, harms, and conflicts. Conceptualizing a restorative justice response does not theoretically depend on any sort of legal or system-based definition of matters. So as such, it has a potential to affiliate itself with environmental regulatory approaches, with criminal justice approaches, and with environmental justice approaches, and so on. And so it can also, as a result, learn from all these sort of conceptual heritages. Related to this point, because restorative justice starts the search for justice not based on the question of which laws have been broken, but focuses on who and what had been harmed, who is accountable for that harm, and how to protect those that are harmed, how to repair the harm and ensure its non-occurrence. A restorative approach has the potential to expand notions of harm and victimhood, also as it is not bound, as I said, by legal or hierarchical or exclusionary understanding of harm and victimhood. So that means that invisible or unconsidered harms and victims can be considered. From this perspective, then all harms and victims of environmental harm, human and other than human, individuals, communities, future generations, and the environment could potentially be taken into account and given a space within restorative processes. So that's the number one. But questions of harm and victimhood and accountability are particularly challenging when we are thinking about the environmental context. And this is due to multiple and intersecting sources of harm, entangled layers of causation, questions surrounding harm to future generations and more than humans. So the most valuable, let's say, contribution that restorative justice can make to addressing environmental conflicts is therefore this creation of spaces, safe and structured spaces, that's very important, for all stakeholders to exchange different views, tell their stories, and hold difficult conversations around, what has happened and what must happen in the future to ensure accountability and repair. So this simple act of sort of respectful talking, listening, and turn taking can be actually very profoundly transformative. Restorative justice requires direct participation of stakeholders, and therefore it is very different from sort of approaches that use delegated forms of participation. And that's because restorative justice works in part through emotional expression, involvement, and presence of stakeholders. And because of that reason, it can create empathy, it can create mutual learning, it can create a better understanding of each other's position, and also engage in direct and sort of widened responsibility among stakeholders. In particular, restorative justice emphasizes a sort of a co-producing an account of the harm and focusing on achieving both a past and future oriented form of justice. So that's the contribution number two. But having such conversations has also to be conceived partly as forms of knowledge sharing. So when we are thinking about nature and natural resources, we have to think that this is perceived in radically different ways by very different stakeholders. And for a company, for example, natural resources are the raw materials from which their products will be made, and which in a capitalist competitive system, the only aim is kind of to have minimal cost for this production. For the state, natural resources are national resources. Also for the state, when they are thinking about national resources, it's mostly the focus on development and progress of one's country. If we are thinking about indigenous populations, nature has a complete different understanding. So for them, it's an intrinsic element of their lives. Of course, it's important for their health or development, but it also has a very strong cultural and sort of symbolic significance. So in other words, what is a natural resource to be exploited by some can be a sacred land for others. So at the very heart of this, I think, of this fundamental divide lies, in fact, the need for knowledge sharing and epistemic dialogue and cohabitation. But to come to the other point, so this dialogical element of restorative justice has also the potential to reduce social distance, and also to reduce domination in an area where distance and domination are enormous. And often they are the cause of the harm. So when engaging in this area, we inevitably enter into an area where there is systemic injustices, extreme power imbalances, and high victim vulnerability. So to correct, let's say, the power differences, we need to engage in processes that, engage in some form of power sharing. And we have to keep in mind that often the affected communities are silenced and they are left out of important decisions that matter to them. So on the other hand, restorative justice calls for dialogue and participation and is therefore in line also with communities and public's rights to decision-making in environmental area, but also access to justice and access to information. So I insist on this, that I think restorative justice also have to be conceived as processes that reduce distance and share power among stakeholders. Prioritizing repair, so that's the core of our perspective of restorative justice. And I must say that it is no secret that in a world that in a way is much more dependent on maintenance and repair than innovation and invention. So the world we live in, actually, the objects, the relations we create are by their very nature breakable. They can decay, they can unravel and fall to pieces. So as feminist philosopher Elizabeth Spellman has written, Homo sapiens is actually also Homo reparans. She has argued that especially in an era when where repair is unavoidable as a result of the accumulated impacts of humanity on the earth and its systems, it is critical to bring repair out of the shadows. The environmental justice perspective is driven largely by the principles of harm, reparation, restoration, and healing of communities, relationships, institutions, and ecosystems that are damaged by human action or inaction. And in cases of environmental harm, simply punishing the perpetrator for the pollution or destruction of ecosystems is meaningless. In a way, if there is no repair to the damage done, or if there is no assurance of non-occurrence, that this behavior will not take place anymore. So as a result of restorative processes and a plan of action or restorative contract, which contains suggestions to prevent or repair the damages that can be done. And because this type of contract or this type of action plan, let's say, is inclusive and participatory, it also has the potential to be sustainable and transformative. So instead of also thinking of reparation very much focused in terms of material, as a material aspect, in restorative justice, it's important to think that we focus a lot also on the emotional, moral, and relational repair. And we can, in fact, when we are thinking about this field, we can argue that I think the thing that is most in need of repair is actually humanity's exploitative and instrumental relationship with the earth. According to the Scottish lawyer Polly Higgins, she drafted the ecocide law and she launched the Stop Ecocide campaign. She's a highly influential and inspirational figure in the rights of nature movement. She argued that we are very different from other species in that we have the capacity to recognize and understand the consequences of our actions, and therefore also to take collective action to remedy them. So her main concern in a way was with how we can take responsibility for the way we engage with our ecosystems. And being held accountable for creating harm and for healing that harm is central to environmental restorative justice. But we also need to think of the term responsibility quite literally. So our ability to respond as we stay with the trouble of living, let's say, in a wounded and a vulnerable earth, to quote feminist philosopher Dawn Haraway. This ability to respond is profoundly endangered by demobilizing trends. These trends are very extremely different, but they lead to the same results. So on the one hand, we have a catastrophism trend, and this leads to despair. We can't do anything, or it's too late. So this is a catastrophism trend. And on the other hand, we also have this sort of ecological techno-utopism trend, which is characterized by naive hopes and some kind of blind faith in technological and fantasy in technological progress. And both trends, as I said, are demobilizing and therefore impede social and moral accountability in relation to environmental harms. And finally, I would like to say that both notions, accountability and repair, and that's why restorative justice is very important in this field, they are closely related to the virtue of humility and restraint. And that recognizes essentially the necessity of limits. So it's very important to think about limits in this field. And why? Because environmental harms and crimes are often characterized by sort of an excessive confidence as I mentioned before, the inevitable technological progress and the need for profit at any cost. So this so-called hubris syndrome impedes, therefore, a respectful relationship with different species or with the earth. And one thing that definitely needs to be restored, therefore, is limits to hubris, or what restorative scholar Gemma Verona has called tu desmesura. And this is a Spanish word that sort of refers to this lack of restraints or modesty. And this restoring of limits takes place through acknowledging and putting into practice limitations on the individual and on the collective level on our behaviors on damaging ecosystems. So in a way, it's really important to think about that this transformation of cultural values is also a precondition for the practice of environmental restorative justice, especially as we look to expand our conversations beyond humans towards other than humans and the environment. So as it must have become quite clear by now, there are many gifts which I believe restorative justice can bring, but there are also some challenges which I think need to be considered. So first of all, the most important challenge, both at the conceptual and at the practical level, responding. It says my internet connection is unstable. Lindsay, can you give me a sign? Are you still with me?
Yep, it cut out for one moment, but you're back. It's looking great.
So responding to complexity remains one of the main challenges of restorative justice in addressing such issues. It's important to think that environmental conflicts are often very long-term and complex. They are rooted in historical past, socioeconomic inequalities, corporate politics, entanglements, global injustices, and colonial history. So the question then is, how well prepared are restorative justice services to navigate this complexity and the multi-layered aspects of these cases, which extend, to very different things, but for example, sophisticated legal procedures, safeguards, difficulties to establish harms and damages, many-sided financial and compensation issues, multi-layer stakeholders and collectives with different interests and needs, but also structural, intersecting, and systemic harms, as I mentioned. Often in such cases, especially if they are long-lasting and very harmful, there are also issues of very deep mistrust and asymmetrical power relations in affected communities. And so the values and principles of restorative justice, with all the good intention, might not be enough to turn the tide. And we can even think that some of the values and principles, for example, stakeholder participation, can even be seen as more of the same. Participation is now promoted by many different approaches. So they might be seen as placatory and instrumental instead of leading to any kind of meaningful transformation. And sometimes this is also important to keep in mind, that restorative intentions or methods might even be in direct conflict with other coexisting strategies in the communities, and especially activist communities, for example, protests and blockades. So we really have to consider our case very carefully, in each case by case. In addition to this sort of more broad issue, which I think needs to be considered, and that's responding to complexity, restorative justice has also another challenge. So it is, as I said, no secret that today restorative justice is created and done by humans and for humans, and therefore, in a way, it's highly anthropocentric approach. So identifying the right stakeholders and giving voice to or listening to non-human forms of life, to nature or the environment, and to future generations remains an important challenge. So who should have a voice in restorative process? Who speaks for these victims, and what sort of processes are we to create to decide on this? Another question that is very important is around the question of expertise. So how do we decide what kind of expertise is important, or what kind of surrogate presence then we will need if we do not have any of these concrete victims in our processes? What sort of expertise then is required to adequately speak for the non-humans, and to speak with authenticity, legitimacy, and credibility? So just very concretely, so is scientific evidence to be acknowledged legal, to be acknowledged sort of expert authority? Are indigenous peoples, are local community groups, activists, environmental agencies, or so on? So there are many questions to consider on who is um, sort of the group that will have the authority to do this. Um, this when we are thinking about the affected, sort of the victims and the harms. On the other hand, also another main challenge, and perhaps I might dare to say that this might be the most important challenge, especially if we are thinking about cases when we are lacking social, political, and judicial pressure. How do we engage with businesses and corporations in a voluntary? Yeah? Because as you probably are very aware of, all of you, voluntariness is a key principle of restorative justice. So how do we, in a voluntary way, engage with corporations and make them acknowledge their responsibility? And many corporations will fail to admit themselves, will to look at themselves as offenders, and will refuse to do so, especially if they are not, like in a stricto sensu sense, breaking the law. You know, even if there are many harms caused by them, or in ethical terms, if there is a reason for them to be present. But if the law, if they don't have the threat of the law on the back, it might be challenging to invite them into our processes. So how do we then identify the accountable stakeholders if we do not have causality established in the court? And how do we also decide on different degrees of accountability? You know? Another question that's central for restorative justice processes in general, so what sort of degree of offender acknowledgement of responsibility should be a prerequisite for participation? So how much should the offender admit? Another challenge is what to do in the cases, and these are many cases are like this. So when the company disappears, or it merges with another, or moves to another country. So in cases of environmental harm, this is a very common situation. So what do we do then? But also let's think, once the restorative option is given within the criminal justice system to the corporations, and let's say they participate. So we've crossed that first challenge and we have them on board. How to ensure that their participation is genuine and not instrumental and motivated only by self-interest. Another question is, what is the role then of also legal representatives or spokesperson? It's a different situation when we are thinking of corporations. We don't have individuals there. We have an entity. So who are to be the main participants, and how will we decide on that? Another question is, who can take binding decisions? Who can follow up commitments? And also, once it has ended, how will we, in a way, follow up compliance or non-compliance with the action plan? And who will do that? Will it be the restorative justice services? Will we need other types of alliances and so on? So the most optimistic accounts when it comes to considering corporations' involvement in restorative justice, the most optimistic accounts, they will argue that, yeah, most corporations have good reasons to also maintain public trust and reputation and right relations with their consumers and with their communities. And for most of them, this will be right. So notions like corporate ethics, corporate responsibility, social license to operate, and also fear of reputational damage, these are all windows that restorative justice can actually use to, to engage corporations and think more seriously about how to engage them. The more pessimistic accounts will warn us. So they will warn us that corporates are cynically and profit-driven. So they will especially warn us against things like automated apologies, greenwashing, but also pre-calculated sort of fines and sanctions that companies take immediately as part of their business plan and so on. So this kind of tokenistic outcomes also. We also have to think of other collectives, for example, for environmental and animal rights activists and so on. Restorative justice might entail the risk of, they might perceive it as not a serious approach or a very soft approach in dealing with corporations. And so it's often the case that many emancipatory sort of movements fall into this punitive trap, and they ask for more punitive reaction because of impunity, and especially when we are thinking about corporates. I think they are right. But of course, it's a trap. We've also seen this with the feminist movement. So asking for more criminalization, punishment, doesn't solve the issue, but we have to enter into a dialogue with these sort of movements and sort of explain what the benefits of restorative justice are and why we shouldn't really go with that heavily criminalizing approach, and we should uh, kind of go with another paradigm change of more accountability and repair. And finally, so the last challenge that I would like to mention is, once we've sort of figured out these sort of stakeholders, so both the methods that can be used and so on, another challenge relates to the criteria by which decisions around restoration are to be made. So whether it is physical or emotional, the process of repair generates ambivalence, and similar processes also applied in other fields, such as we can think about reconstruction of historical heritage, remediation of human bodies, restoration of ecosystems, reconciliation of relationship, and reconfiguration of cultural artifacts. These are full of debates already about ethical issues and ambivalences of repair. So should we repair? When to repair? How to disentangle material from non-material priorities. But also in this field, how to repair individual and collective harms when the impacts of such harms might actually also be visible only in the very long term. And eventually the very difficult question, how to repair the irreparable, and can irreversible environmental degradation be healed? So these are all, another difficulty can also arise when we are thinking about decisions to repair, when we have conflicting interests. So can restorative justice simultaneously safeguard communities and the environment? And how to meet also diverging needs of different victims groups and so on. So I think healing and repair, we always have to keep in mind, of course, it's a normative intention of restorative justice, and it's very important, but we always have to think of them as dynamic processes, right? They are context-based, they are relational, and we always have to take into account the particular histories, values, inhabitants, and potentialities of each context when we are considering repair. So the challenges I mentioned here are not, let's say, insuperable problems, but they do point to the need of continuing to develop a theoretical, practical, and conceptual environmental restorative justice agenda, where we are in a way sharing insights, ideas, and experiences among different groups of people engaging in the field, and also learn from other disciplines. Is very important. So in the last part of the lecture, I will draw on some worldwide existing experiences of environmental restorative justice. And I think that also helps to sort of visualize what that could be. So very exciting. So the first one, you see there, rights of nature, stop ecocide, duty of care, and restorative justice. This is a very exciting, in my view, intersection between such movements. And these are also kind of proponents of earth jurisprudence and restorative justice. And I think at the superficial level, a lot of people think like that. So at a very superficial level, it almost looks like such movements are asking for more laws, essentially. So it's a very legalistic approach. I think they can be aligned with restorative justice because what these movements ask is also very much a paradigmatic change of how we actually relate to our system, to nature, and so on. So seeing the broken relationship between humans and nature, and the commodification of nature at the heart of the problem, these type of movements argue that we need to move collectively from a right to exploit to a duty of care. And first we do that at the consciousness level, and eventually we translate this into binding laws and ethics. So first they argue for a fundamental relational change between humans, non-humans, and the environment, when humans are not the owners, but they feel part of the environment. And second, they argue, and this is a very strong argument that they make, that the legal system should be then at the service of this new relation and this new balance. So in terms of legal mechanism, these proponents have put forward, I think one of the most important ones that we can highlight is the concerted efforts that have advocated for the amendment of the Rome Statute of the International Criminal Court to include ecocide as an international crime. Another mechanism has been the recognition of the rights of nature within a legal system. And these rights are then in turn expected to create legal duties for legal persons or entities, so it can be corporations, states, and so on, to respect the rights of nature. And worth mentioning here is, of course, you'll all be familiar with this, but the Universal Declaration of the Rights of Mother Earth. At the same time, there are countless examples of rivers, mountains, forests, and glaciers in New Zealand, Colombia, Ecuador, and India that have been recognized by national courts and legislations as living entities with their own legal rights and legal personhood. We also have to think about emerging jurisprudence that is recognizing the rights of future generations to participate in judicial proceedings. So I think you might be asking yourself, how such, as I said before, what can be perceived as quite legalistic movements interact or find connections with environmental restorative justice. In fact, it was Polly Higgins, who drafted, as I mentioned before, the Ecocide Act and started the Stop Ecocide movement, who came up with the idea of using restorative justice as part of the sentencing process for ecocide conviction. More specifically, in 2011, her draft Ecocide Act was tested in the UK Supreme Court in a mock trial. And one of the two fictional CEOs, which were charged for ecocide in the Athabasca tar sands and the Gulf of Mexico, they chose to go through, so one of them chose to go through a restorative process. As part of this mock trial, and you see here a real picture of the meeting, former chair of the UK Restorative Justice Council, Lawrence Kershen, facilitated the restorative circle that was part of the Athabasca tar sand case. For Higgins, restorative justice was radical because it offered the tools to allow those who have made the decisions to cause harm to face that harm in a healing space without perpetuating a culture of blame, but instead nourishing a more meaningful and enduring accountability. As facilitators, Lawrence Kershen has reported on this process and currently is working also on a video which will be made available for everyone interested. One of the major challenges of this process was, as I mentioned before, this identification of who are the appropriate parties and what interests could and should be represented in the restorative circle. So the restorative process had participants, you'll see all of them sitting, and they spoke on behalf of the earth. We had someone representing the birds, we had someone representing the future generations, as well as those that were more immediately harmed, which were First Nations people. So in terms of sentencing, it's interesting to keep in mind that the CEO, who had not agreed to go through a restorative process, received at the end a prison sentence of 4 years. And the CEO, who agreed to be part of this circle, got a deferred sentence, which depended on the implementation of the action plan that was decided in the circle. And the action plan was very varied, and it served the interest of many of the stakeholders sitting there. So you can ask yourself, you know, when we are thinking about what do we want as a result in such cases, when you compare the years of imprisonment with repair actions, you know, what is worth to do. So it's important to mention that currently there are no legislations which formally recognize both the rights of nature and the possibility of restorative justice to be somehow, applied when these rights are infringed. We do have, as I mentioned before, and we do also have real processes where trees and rivers have been represented as victims of their own rights in several restorative justice conferences in New Zealand and Canada. However, these cases do not concern, let's say, trees and rivers whose rights have been officially recognized through the rights of nature mechanisms. Nevertheless, within the intersection of these movements, several advocates and artists are proposing mechanisms. And one of these has been the Rights of Nature Restorative Circles mechanism, Rights of Nature Guardianship, and also Council of All Being sessions to experiment with uniting the both ideas together. So I'd like to, I can't say too much because of time limitations, but I would like to draw your attention to the work of the Dutch lawyer Femke Wedekop and her website earthrestorativejustice.org. So inspired by this ecocide mock trial, in 2019, environmental artist Maria Lucia Cruz Correa created an art-based intervention of a restorative court. She transformed a real court into a restorative court, and this was called The Voice of Nature, the trial. In this work, in which I collaborated, the artist designed participatory experiences of this restorative court intervention, where she brought in victims' testimonies, ecocide lawyers, ways to listen to the voice of nature. You see there the performer with a tree. So also failed attempts to do that. There were several attempts to listen to the voice of nature, but of course, some of them are very frustrating and they are failed. And she also brought commitment to become guardians of nature and restorative contracts. So it was a bit of a merging of different ideas together. And currently we are also working with the artist on a long-term project on recognition of the rights of a river and the guardianship for a damaged river in Belgium, where we also bring restorative circles in combination with the rights of nature and guardianship ideas. And I have to say there are several. So if you start looking, there are several artistic collectives who are cooperating also with scientists and so on, who are now experimenting with the idea of creating, for example, formal assemblies, courts, and parliaments for nature rights and other beings. The court experience, so with restorative justice for environmental crime, does not take place only in, let's say, performative courts. It also takes place in real courts. The most advanced experience in this field that we have today comes to us from Australia, New Zealand, and Canada. In Australia and New Zealand, there are several specialist environmental courts that have experimented with restorative justice conferences and sentencing, and restorative justice has been included in the environmental protection legislation. So in the context of environmental offending, restorative justice conferences have been used both as an alternative to prosecution and at the pre-sentencing level, where the results of the conference have been taken into account into the sentencing process. At the same time, a variety of restorative-oriented orders have also been imposed by the courts where, let's say, there has not been a voluntary or a deliberative sort of restorative process, but there have been restorative orders imposed. And several authors have actually argued that in the environmental harms case, we might also live with this idea of not having a deliberative and voluntary restorative process, but we might have to live with the idea of restorative imposed court-imposed orders. Another interesting experience worth mentioning in this field is the work of Dominic Barter, which is, he's a restorative leader in the field, with the Renova Foundation in Brazil. So the Renova Foundation was set up by the federal government in cooperation with Samarco Mining and other companies. And they were the owners of the tailing dam, which collapsed in 2015 and caused really bad environmental disaster in the state of Minas Gerais. So the company signed an agreement, the so-called transaction term and adjustment of conduct agreement, with the federal state and the state, with the federal and state prosecutors. And this agreement defined 42 programs and created the Renova Foundation to sort of manage the revitalization projects that were to take place along this Dotse River, which had actually died due to the environmental damage. So this foundation is a very interesting example. It coordinates sort of, it incorporates more than 70 public and private entities, including federal, state, and municipal governments, mining companies, about 30 research institutions, and many, many more civil society organizations. And so the work of Renova, supported by Dominic Barter, has included in the design of specific restorative intervention the need for identifying needs and creating processes so that these needs can be met, but also creating spaces for mourning and responding to the multiple conflicts that were arising within communities. So it's not just the environmental damage that has to be healed, but they are cause for so many sort of proliferating conflicts within the communities where we can sort of contribute with our approach. And I think the most important thing is that he sort of incorporated this restorative dialogic approach at the meta level. So throughout the decision-making of this whole Renova Foundation was a sort of restorative philosophy. And I think it's very important to think of this sort of more cultural, restorative cultural change within an organization. Canada, more specifically British Columbia, is also currently breaking new grounds with the use of the community environmental justice forums. And this is sort of an enforcement tool that applies the principles of restorative justice to deal with companies who break environmental laws and unintentionally commit non-compliance. The forums offer those companies the opportunity to make reparations for the community in which they operate and live, and working with the community to repair or compensate for the harm, it helps the company restore, let's say, its social license to operate and identify and fix also problems that the company might not otherwise see surface within its operations. It also sort of provides this space to the company to align itself with the values and of the community, but also to educate the community about its operations and can result therefore also in extremely positive relations. So there are a number of criteria for these community forums to be met in order to be appropriate for stakeholders to participate. And this is a concept that is a difficult concept, but essentially they expect the company to be remorseful and demonstrate sincere interest in repairing the wrong. And of course, when you are thinking about a company being remorseful or sincere, it's a complete different way of looking at it when you are comparing it to an individual way of being remorseful. So I think, for example, looking at the regulatory history of the company is also already a good indication of what sort of line a company follows in this sense. Participants are selected in such forums by the facilitator, and they involve employees that were directly involved into the harm, but also high-level managers and executive. And community participants are also chosen to represent community interest, but they are especially chosen if they can account and narrate the harm that has taken place. I think that's quite central. So ideally, they try to also match the number of people participating from the company side and from the community side. And they also have some kind of an investigating officer present in order to clarify factual sort of information in the case. And they might also have a ministry expert attend to also address technical questions, which might be difficult for the other participants. So I think this is quite promising experience, the community forums of Canada, and I definitely think there might be cases that are to be studied, and we have a lot to learn in these cases because they are applied. They are not just conceptual. So now I'm gonna just mention a few initiatives which are taking place outside the criminal justice system, and they are precious for very different reasons from the ones I mentioned before. So in South Africa in 2019, there was a pilot project that was launched that seek to apply restorative justice principles to wildlife offenses in South Africa. And it was started by a local conservation NGO, the Endangered Wildlife Trust, which collaborated, and I really like this collaboration because I think it's quite a model for how things should move on. It collaborated with the Restorative Justice Center and also the University of Cape Town. And what was important is that environmental authorities have relied in this field exclusively on criminal measures, and the conservation groups have even used kind of quasi-military measures. So the rationale for this pilot project is that to change the tide, to let's say, use restorative justice principles, but in a way in tandem with the criminal justice system. So it's not an alternative, proposing an alternative, but it's really trying to say there are several issues with this very criminalizing, very militaristic approach. We need to go another way here. We need to carefully look at our harm landscape. We need to involve our communities in our decision making, and this might be more sustainable. So the project is ongoing, but I find it quite an innovative project because it is long term. So it started in 2019, it's ongoing, it will last several years. It is based on research, which is really important in this field because it's a new developing field. So we do need research, we do need to know how we can evaluate ongoing things. And also is an interdisciplinary collaboration between different approaches and institutes. And I think this is also crucial in this field because we have so much to learn from each other in our approach. So this is, if I can say, I think I find this the way forward. So kind of sustained pilot projects, I think it's quite important. If you don't have in your countries legislation that is ready, and like New Zealand, for example, or like Canada, that has in place already some restorative justice interventions. Besides the ones that I mentioned before, there are also some kind of more ad hoc initiatives. And as I said, they are unrelated to the criminal justice system. Conflicts within local communities. For example, in France, there was a restorative circle in a community of farmers affected by disseminated pesticide pollution. In Ecuador, and this is a picture you see here, restorative circles were addressing wildlife community conflicts by a field biologist who was interested in protecting birds of prey, and that was in conflict with the community because the birds of prey attack domestic animals and also compete for food in these areas where the indigenous people also use the birds of prey as food. So it's quite interesting. I mean, it was ad hoc in the sense that it was a chance encounter of her with a restorative justice facilitator who taught her about this approach and where it gave her the idea. But she thinks about this and she reflects and writes about this as it has completely changed her practice as a scientist. So it's quite interesting. Another initiative is Action for Bhopal. I don't know, some of you might have heard of it. And this is at the intersection of a pressure group, something of a pressure group, awareness group, and a restorative philosophy combined. And it is started by restorative justice pioneer Martin Wright. And Bhopal remains one of the most difficult, one of the most, worldwide, the worst industrial ingoing ecocide cases in a way. And so it's very long. It's about 35 years now that issues are not solved, and it has had a very tumultuous, a very tortuous engagement with the justice system. And so this group is trying to engage the companies in some kind of a dialogue, and it has proved so far unsuccessful, but they haven't given up hope, and they are not suing the companies. They just want the companies dialogue, and they want to engage in a restorative dialogue so that they can ask them to repair towards exactly repair and accountability, what I mentioned before. There are also several examples of restorative facilitators engaging in activist conflicts, because there are also several conflicts that come within, for example, in UK, Extinction Rebellion has had several conflicts with communities, but also among activists themselves. So that's also another area where, you're not engaging in environmental harm itself, but there is a space to engage in environmental related types of conflicts. And this can be, as I said before, a spectrum of very different types of things. There is also something coming from victims movements, so that's something we should not forget. Victims movements, and in Japan, there is a researcher called Orika Komatsubara, and she's done really pioneering work into studying this victim movement. And although the justice system has sort of done its things, there were civil cases ongoing, the victim movement sort of engaged into this movement just sort of to repair the community after also an environmental damage that took place in Minamata. And so she's studying this movement, and she's also trying to understand what's the connection of this movement with the restorative philosophy and so on. So that's also something you can look up. Orika Komatsubara from Japan. So having said that, I don't want to be repetitive, and I've said some of these things already before, so I'm not really going to say what I wanted to say too much. I don't want to take time, but it's important that when we are thinking about the principles of environmental justice, we should think of this as relationally focused. And that is at several levels. Relationally focused in a way that relationality, restorative, Jennifer Llewellyn, who's also another restorative justice scholar, has written a lot about this relational approach of restorative justice. And in what way is this relational approach? Well, first of all, the relationality is a fact. It's a fact of life. So we are embedded into relationality. There is no way you can surpass that. Second, we think about relationality in terms of the harm that has been caused, and eventually also to the aspired relationality. Okay, the harm has been caused. What sort of relationality do we aspire to, and how do we want to transform it? So that is one. The second point, I already mentioned before. So it has to be participatory. It has to be balanced. Balanced, I mean, the stakeholders' interests, both the victims and the offenders, have to be taken into account. And it has to be collaborative, so not adversarial, because then it does not really serve a restorative purpose. It also has to be culturally based and responsive according to the context. I think I mentioned that before. It's really important. So we should identify a little bit what I'm doing now. We should identify principles that make restorative justice legible. We need to know what this paradigm is about, what are its philosophies and so on. But the way this applies is so much context-based and how much, so it has to be translated. We can't just say we know a formula, we have a recipe, and then we do it. Repair and healing oriented, I think I've said enough about that. Accountability and responsibility oriented also. So maybe just a last point. Past and future focused. So this is also very important, because restorative justice in a way is like Janus face. It looks both at the past, but it also looks at the future. And so it calls attention to two different things simultaneously, and also doesn't see a contradiction in that. First of all is the necessity to acknowledge and repair the harms that already have been done to the environment, to humans and other than humans and so on, but also to build different relational and ethical futures so that we can prevent harm for future generations. So it can be both healing and reparative, as it can be educative, preventative, and proactive. And so it is, I also, as I argued with the pilot project, I think it's quite clear. I believe it's at its best when it is sustained and not incident-based. So we're not really going to target and address environmental harms with one circle or just one meeting. We need to sort of engage and design processes that are, we need a long-term commitment to sort of a form of justice that is really environmental, that is human-based, but also that is interspecies oriented. So these were the sort of the main points that I want to make. And I'm going to stop sharing the screen and try to see you all.
Wonderful. Thank you so much, Dr. Pali, for that fascinating discussion of an emerging area in the restorative justice field and environmental justice fields. Just fascinating. I'm taking notes like crazy over here. And so I know I'm mindful that we're just past the hour, but I'm hoping that you'll stay with us, Dr. Pali, for anyone who can come on, who can stick around a little bit longer so that we have time for a few questions and answers as well. So what I'll ask you to do if you have a question is to use the reactions function and where you can select to raise your hand in Zoom. And then I can go ahead and spotlight you so that you can ask your question in person. Or you are also free, of course, to use the chat function if you find that easier. But while people are figuring out that functionality, I did have one question. Maybe I'll jump in with, if that's okay, Bruna. I was curious to know, when you talk about this ecocide mock trial and the action plan that resulted, would you be willing to give one or two examples of items that were on that action plan, just to kind of flesh out what that repair would look like in that mock trial?
Yeah, so I don't remember exactly all the details, but I think it was also things like funding, for example, research institutions or civil society organizations that were, for example, the birds were harmed. And so there was an institution there representing this, representing the birds. And so there are from investment to educational measures to, it can also be money, it can be compensation, but the money is not just a fine that is meaningless, you know, and goes, for example, to the state and you don't know where it goes. If there is a money sort of action that comes up, it's not a fine, but it's an investment into something that makes sense. And I find that in a way a very strong way of conceiving. So it can be also just practical investment into actual repair. This also can be very, very actual repair into the environment. But if that's not possible, or if it's not appropriate to the case, it can be really just funding research institutions, funding communities whose livelihood has been harmed, and so on. But this, as I said, the ecocide mock trial, so there hasn't been so much written on it yet, but you can find it on a paper. I'm try later to write this on the chat, by Liz Waters, and she wrote about exactly all the details that came up in the circle. Plus, as I said, there will be now, I've watched it myself, there is a movie that Lawrence Kershen released of this. And I have to say, just like from the first impression, I found it extremely interesting to watch that. I mean, everything that I'm saying in principle and in words sounds really great, but it was a little difficult for me to watch, for example, the actors, so the surrogate victims, let's say, the ones who speak for the earth or the ones who speak for the future generations. It happened time and again that I found myself not so convinced. I mean, the circle went fine, and I think everybody in that circle was convinced. But me watching it, I had lots of questions about who should do that role, and how is exactly that a credible sort of participation in those circles. And time and again, I found myself sympathizing with the company guy, because he was just so much more real. And it was really his company. He knew what he was talking about, in the sense that although it's a mock trial, so he was also not real, but the way he was sort of embodying this role was very convincing. So that's something that has been on my mind a lot. This sort of, and I mentioned it as a challenge, the representation of the voice of the non-human, you know, and so on. So I'll try to find the reference for the people.
Thank you. And I'm also happy to send out an email afterwards if there's a number of different references that you'd like to share with participants. We could follow up with that information. I see Joan has her hand raised, so I'm going to come and spotlight you, Joan, so that you can ask your question.
Brunilda, I just want to say that this has been a fascinating presentation, and at so many levels in terms of conceptual clarity and practicality. One thing, though, I'd like to hear more from you about is in the context of environmental justice, what does epistemic cohabitation mean in practice?
Yeah, that's not. That's another one that is easier to say, but a little bit more challenging to do. Nevertheless, I think there are several. For example, even in the science now, I mentioned the scientists, the field biologists in Ecuador. There are several scientists who have realized, also in the conservation area, in different areas where they go, that that science can also be done by this way of, I am the expert, I know what's happening, and you are damaging the ecosystem and I protect it. So that has been quite, for very long, the attitude. Whereas now you have many scientists who realize the pitfalls of that approach, and also how the scientific expertise can be and has been quite violent to many communities, and has in a way devaluated their knowledge and their way of doing. And we also realize with lots of like climate change issues that with fires and this and that, that it's a type of knowledge, the indigenous knowledge, is a type of knowledge that we have devalued. We have devalued and we can learn from it. So epistemic cohabitation is an aspiration, I think it's an idea of, is there a way of us sharing this knowledge? And I think there is, because there are several collectives, as I said, that do this. But it has to be done in a careful way. And I'm not saying it's going to be always without tensions. It cannot be just, okay, what do you indigenous people think about that? And give me the knowledge. Sometimes they can be quite much in conflict, I think, these knowledges. But the intention of cohabitation and the intention of closing that gap and showing respect, I think can lead to much more, let's say, sustainable and transformative way of thinking about knowledge. So in my view, the restorative circles have a very large potential at enabling that knowledge sharing, and so addressing also the tensions which are part of that knowledge sharing, and try to understand why is a certain knowledge developed and devalued and so on. But there are difficult decisions to be made. So in order to be able to do that, to have all the types of knowledges within a circle, let's say, somebody has to decide who has a knowledge. And so that's what I mean by the restorative facilitator then. If the restorative facilitator is the one that will make those decisions, needs to be very much aware of this need for epistemic cohabitation. Otherwise, they will pick the first expert they think it's an expert. And where you are based is what you believe as expertise. So if you are part of an academic community, you will call the biologist, you will call the expert who in your view is an expert. If you're part of a community, you will call your elder, and so on and so forth. So we need to have this sort of reflection all the time before we are making the decisions, and inviting people to what sort of knowledges are there, which sort of knowledges are forgotten, silenced, and so on.
Thank you.
Thank you. Let's see, I'm seeing a clarifying question in the chat here from Jenny, wondering if the incident, I assume this is for the mock trial, that was used was one where there were hundreds of ducks that landed on Tailings Pond. Is that?
Yeah.
That was the incident. Okay, great. Other questions at this point for Brunilda? Great, wonderful. Well, I just want to say thank you again so much for this fascinating talk. And I know many of the people here will have further opportunities to connect with you throughout the week. And maybe would it be okay for when we share additional resources in a follow-up email to share your contact information as well if questions arise?
Yeah, so that's something I wanted to say, Lindsay. I'm also on the side beside this book that will come up, and I really think it will be quite an interesting resource for people to have, because we are writing with Miranda Forsyth a handbook on environmental restorative justice, so that will be a great resource. But on the side, I'm also myself keeping a biography references on everything that has been written on the topic. So I'll be very happy to share the document with everyone who wants it, and you can do this however it's most practical. I can send it to you and people can ask you and so on. So I'll be happy to share that.
Great. Yeah, wonderful. Such exciting work. And yeah, I imagine that's probably a resource that everyone on this call would love to have. So maybe we'll just send one follow-up email with everything. So thank you again to everyone for attending. And thank you to Dr. Pali for a fascinating talk. And for those of you in Vermont, we'll have other chances to see you throughout the week that she's here with us. So thank you. Thank you.
Thanks, everyone.